Hi, Ed. If you want to get us started and welcome everyone, that would be great.
Thank you, Lindsay. Good morning, everyone, and welcome to the Affordable Housing Professionals of New Jersey webinar concerning the recent reforms to the Municipal Housing Act obligations and the implications of the new law. My name is Ed Schmier. I am the president of the Affordable Housing Professionals of New Jersey, and we're pleased to be able to present this webinar today, hopefully to go over some of the nuts and the bolts related to the March legislation that was passed, which significantly reformed how one approaches affordable housing here in New Jersey as we get ready for the fourth round. Lots to cover, so I'd like to turn the program over to my colleague on the board, Brian Rappaport. He chairs our program committee. Brian, why don't you kick it off and we'll introduce our speakers.
Hi, everyone. I just wanted to introduce the panel today. I think it's an important topic that will help with the fast-changing landscape in New Jersey. We're going to have 5 panelist speakers today. We have Josh Bowers with the Fair Share Housing Center. We have Mary Beth Lonergan with Clark Caton Hintz. We have Megan York with CGP&H. We have Elaine Glissom with Clark Caton Hintz also, and Samantha Hennessy with the Alpert Group. And we're going to be talking, Josh will give a little bit of a PowerPoint to go over the new law. Mary Beth will discuss the statutory and regulatory framework, discuss the law in a little bit more detail. Elaine will cover trust funds. Megan will cover administration, and Samantha will give a developer's perspective on the law. With that, I'll turn it over to Josh.
Thank you, Brian. I'm just going to share my screen real quick, and let's make sure that we are, I think we're good to go, right? Okay. So, as Brian said, we are going to do a presentation about the new legislation. My task is to do the quick overview. I'm going to do maybe a few minutes just sort of going through the nuts and bolts of the bill, and then the idea is that we're going to go a little bit more deeply into some of the things that are important for administrators of affordable housing and maybe some of the municipal housing liaisons and that sort of stuff. So as everybody should know, we have a major update to the Fair Housing Act. We're generally calling it the new affordable housing legislation. Really, the bill numbers are A4S50. It doesn't have a snazzy title yet, as far as I'm aware. I think maybe that's something we can work on, but for now, we're calling it A4S50. The key takeaways are, I think, first of all, the Council on Affordable Housing is being abolished. I think the idea is that we are going to maintain and improve upon some of the process that we utilize in the third round. One of the ways that we're doing that is with a very specific methodology in the statute. And for this audience, I think obviously there are some really important things that are included in the bill, including updates to, we're going to get updated UHAC. We're going to get updated trust fund regulation. We're going to get some other updates to for administrative agents, for certification and that sort of stuff. In a nutshell, generally speaking, we're basically, we're abolishing COA, and we're basically replacing some of the functions of COA with a mediation program in the courts. We're going to have a very specific methodology. One of the other big major changes is there is a change to the bonus structure that towns can utilize. I'm going to get more deep into that in a few minutes. And then There's also going to be some major changes to things like the affordability controls, including specifically 40-year controls for rentals rather than 30. And the bill, I think, throughout in a number of different places, continues to emphasize family housing. I think has some renewed emphasis on redevelopment and transit-oriented development, and also has some emphasis on supportive housing. So we've basically taken the COA process and permanently sidelined that. COA is abolished. And so what is the new process for towns to actually figure out to sort out their housing plans? So first of all, as I said a minute ago, there's going to be a very specific methodology in the bill that is based upon the Jacobson decision, Judge Jacobson's decision from 2018. And so the process is going to be as follows. The DCA is going to be responsible for generating a report based on that methodology. That report is going to be advisory, but I would hope would be pretty influential on what towns are ultimately going to do. The towns have to say what their fair share obligations are by January 31st, 2025. So they basically have 2 months with the 2 to 3 months with the numbers, and with the numbers that are handed down by DCA, and then the towns have to say what they think their numbers are. Then there's a process to challenge the number. My expectation and my hope is that we really won't have that many of these challenges, because it is so the methodology is now specifically in the bill. So you shouldn't be able to come up with a different number unless you're trying to. And in that case, obviously it'll be challenged. Basically, there's a month for the challenge and then a month to resolve the challenge. Those are all going to be set out with the process for which that is going to be done. We're still going to see some rulemaking from the courts, and so we don't know exactly what the actual nuts and bolts of that process is going to be, but we know that it's coming. Either way, the towns have to file an adopted housing element and fair share plan by June 30th of 2025, and they also have to present draft ordinances that will be utilized to implement that housing element and fair share plan. Then there is a 2-month period where people are going to get to review it. Interested parties, developers, anybody that's interested in affordable housing in that particular town is going to have 2 months to review it, and then file a challenge if they choose. And this is where I think we're getting into sort of the somewhat novel part of this. Is there's going to be a challenge, and I think where things broke down in the last round was what to do when the plan is challenged. I think last time it ended up just in sort of endless mediation. What this process does is it sets up a very specific mediation process with an expectation that it is going to be concluded by December 31st, 2025. And so again, there's going to be some rules around this and some rulemaking from the courts as to how they expect this all to go. But there's going to be a heavy emphasis on resolving disputes in those 4 months between August and December. Any unresolved disputes are then going to be submitted to so-called county level housing judges, kind of like where we are now, except those county level housing judges will have more specific instructions for how to resolve and or how to decide any remaining disputes. And finally, the expectation is that we're going to have all of the ordinances, no matter what, are intended to be adopted by March 15, 2026. So how are we actually sorting out the number? As I said before, there's one of the things that is a significant change from how we used to do this to how we're doing this now is it used to be there was sort of some baseline guidelines and parameters in the bill for an agency to come up with the methodology. And what we've realized, I think, obviously over time, is that's where COA ultimately had a lot of the issues, was after the prior round methodology was utilized, COA started tinkering with it in 2004 and really after that, and that is where things ultimately kind of broke down. And so in this bill, there is a very specific methodology. It is not really, you're not permitted to come up with different ways to calculate your number. You're required to calculate it in the method that is utilized by Judge Jacobson in the 2018 decision, with some modifications that are in the bill, and all of those modifications actually simplify. And so the methodology is simpler and it is specific. You know, as I said, I think the idea here is that we're trying to reduce fights over the fair share obligations. I think one of the things that colored a lot of the third round was towns were expected to file their plans, and there were a lot of complaints about not really knowing what their number, not having a specific declaration of what their number was. They were expected to figure it out themselves. In this case, we're going to have a much simpler methodology with guidance from the DCA. And really, what's going to happen is we're going to get to March 31st of next year, and one of three things is going to happen. Either the town's calculation is going to be found to not facially comply with the statute, in which case the town is going to lose immunity from builder's remedy lawsuits. The town's calculation is going to be adjusted. Maybe there was an honest mistake or some error or whatever, and the number is going to be adjusted, and the town is going to keep immunity, or the town's number is going to be upheld and the challenge will be rejected. There's only those three things are possible. The planning process, another thing that I think is a great improvement from how we did things in the last round is, you know, especially assuming if towns, now that we have this bill, we know what we need to do to start planning for affordable housing for next year. So we really have a year to start planning. But even still, even if you wait until October, you know, one of the things that happened in the last round was the Supreme Court expected that all these things would be resolved within 5 months, and that included figuring out the number and planning for the number. In this case, we're going to have the number or a real clear guidance document on the number in October, and then we're going to have basically until June 30th to actually finalize and adopt the fair share plan. I think that this is a really good improvement, and one that's going to allow for more planning and a longer period of planning in order to, I think, hopefully come up with some really good affordable housing sites and a lot more compliance. You know, as I said, there's a process in place for dealing with challenges to the fair share plans that are adopted, with the expectation that those challenges will be resolved by the end of the year. Some of the things that I think are specifically called out in the bill that I want to just touch on, I know I'm trying to fire through this real quick. So one major change is that there are no more rental bonuses. And so I think we have all lived for a long time with towns utilizing rental bonuses. I think in 2024, and especially going forward, I think there's a clear understanding that rental bonuses don't really make sense in this environment. And so they are gone, and they're replaced with a variety of other bonuses. So towns can get one whole bonus for special needs or supportive housing. They can get a whole bonus for contributing funds to a 100% affordable development, and for facilitating market to affordable units. They get a half a bonus for partnering with nonprofits for sale units. That kind of sounds like a Habitat for Humanity bonus. TOD bonuses, redevelopment bonuses, and then, you know, obviously at the end here we have the 3-bedroom and the very low income bonuses, you know, really oriented towards family housing, and then extension of expiring controls. I know others are going to go more deeply into this, but there's going to be a new process for the DCA is taking over responsibility for administering trust funds. There's going to be some rulemaking. I know others are going to go into this, so I'm going to actually skip this slide more or less. Same thing goes with the administration of affordable housing units. There's going to be more rulemaking, and the DCA is now going to be responsible for training and certifying MHLs and administrative agents. And again, we're expecting that we're going to have new rulemaking, including updated UHAC regulations, within 9 months of the bill, which puts us in December. So the crowds can, I'll wait a minute so all the crowds can finish their applause that we're finally going to get updated UHAC regulations. But obviously, I think everybody's really excited about that. And then lastly, there were a series of so-called toolkit bills that were also adopted and passed at the same time and signed into law at the same time. I think some of these, I think, are more meaningful than others, and maybe have some other some importance to some different folks. There's going to be I think the one that I think is probably the one that is going to have the biggest impact is the last one, which is this S2312. It's basically a way that it really is an additional tool for towns to try to build affordable housing and also to retain affordable housing by basically offering an additional way to provide a pilot to a development. This was something that was really key, or not key, it was something that I think we noticed in the last round as we were trying to extend the affordability controls. One of the things that we know is going to be useful and necessary is getting more funds to these kinds of developments, and there really was no mechanism. You're really left with either having the town make a lump sum payment to a development, which many towns are just not in a position to do that. But we're maybe in a position where they could offer a pilot or some kind of tax savings in that way over a period of 20 or 30 years. But there was no mechanism in the law that permitted it, because you would either have to put the site in a area in need of redevelopment, which in this case, when we're talking about extending affordability controls, we're not talking about redevelopment. We're talking about keeping the site exactly the way that it is. Or you'd have to go through the HMFA pilot process, which these sites really weren't eligible for. And so I think this is a new way to try to get some additional funds to development to try to maintain affordable housing. I think it's really good. And I would check out the other bills if you have a minute, but that's the one that I think is probably going to be the most important. I thought I had 15 minutes. I'm at 14 and a half, so I'm going to stop and let somebody else talk, and obviously we can answer questions at the end. Thank you, guys.
Yep, I think now we're gonna pause for a poll question. Do you think the points and bonus systems for developers and townships is more effective after this legislative change? Yes, no, it depends on the project being proposed.
And I put this in the chat to folks, but just as a verbal reminder that participating in the polls will help you get your CEUs. So if that's important to you, please make sure to participate in the polls. There will be 4 total.
Good morning, everyone. I'm the next speaker, Mary Beth Lonergan with Clark Caton Hintz. I wanted to just build off of what Josh just presented, and really all of the panelists will be focusing on how the new affordable housing legislation and the new law impacts administrative agents and municipal housing liaisons. We'll, as Josh started to do, we'll highlight what's coming with new rules, amended rules, new actually use of COA's existing rules. There will be some of that, as well as new statutory requirements. The Affordable Housing Professionals of New Jersey, this organization, will be presenting a series of seminars over the next months, right through the summer, right into the fall. And we're going to do deep dives on various topics. This first one, we wanted to really focus on administrative agents and municipal housing liaisons because, that's part of the focus of this organization, as well as we've got a we have a deadline for trust funds that's coming up with some administrative agents and some MHLs do participate in that trust fund reporting requirement. So again, AHPNJ will be doing a series of seminars, and so please, stay tuned. We will, as we understand and get more interpretations, we will be presenting more and more speakers and focusing on different topics. So at this point, I wanted to just spend a little bit of time on the revised existing rules and new procedures. So in addition to what Josh noted, that HMFA, New Jersey Housing and Mortgage Finance Agency, will be updating and is required to be updating UHAC, Uniform Housing Affordability Controls. As Josh noted, that's going to be no later than December of this year. In addition, DCA, Department of Community Affairs, will be proposing new rules on all sorts of different topics, including AAs, MHLs, spending plans, and so forth. What's interesting is I heard Josh say that the court program, this new judiciary-based affordable housing dispute resolution program, and most of us will be referring to it as the courts program. I heard Josh note that they may be promulgating regulations. I spoke to others that may think they may just be preparing procedures or guidelines, and we'll see what actually happens, whether they will be real rules or just guidelines. And there is and I'll get to the point about rulemaking and guideline or process, and how we as planners and attorneys and administrative agents, how we can influence potentially this rulemaking or process provisions. I wanted to just be clear that with that court program, they will be presenting and preparing, as Josh had started to note that they will be preparing a process for mediation, whether there will be challenges to a municipality's number or to their housing element and fair share plan. Also, this court program will be in charge of reviewing towns' housing elements and fair share plans, and also approving them. There will have to be a process or regulations as noted for that entire new court-handled process. Interestingly, COA's regulations, COA's current in COA, Council on Affordable Housing, the entity that has been abolished, the state agency that has been abolished, but COA's regulations are still in play, and that's really important, and I'll highlight this again. COA's regulations is upheld by the New Jersey Supreme Court for second round, prior round usage, third round usage, to the extent the third round COA regulations, some of them were specifically upheld in the 2015 Mount Laurel 4 Supreme Court decision. So prior round and third round regulations are still in play, and specifically the new affordable housing law lets us know that COA's current regulations regarding credits, adjustments, and some compliance mechanisms, again, are still in play. The point is, the law tells us that as long as the new law doesn't invalidate or supersede a specific point discussed in COA's current regulations, those regulations are still in play for not only historic perspective, because remember, the new law is telling us that we, affordable housing planners and municipal representatives, developers, that towns must still address their prior round obligations. So it's not like our fourth round plans will just be focused on the fourth round. They also have to focus on the prior third round and the prior round, which is, as you know, the first and second rounds. What's unusual in my mind about the new law is that many of the really nitty-gritty details for an affordable housing program are now in the Fair Housing Act or in the statute. The issue with this is that typically COA's regulations would have implemented the statutory requirements and would have provided a whole rulemaking process. And I wanted to just let you know that a few things come to mind when I think about that some affordable housing details will be in a statute as opposed to be in adopted regulations. So typically, in adopting regulations, as opposed to just having it be in a statute, a state agency will have promulgated the regulations, notice for public comments, and what's most important to many of us involved in this field is that the state agency issues a comment and response document. And this type of document has been used, literally throughout the decades, and it's used as an important insight into or provides that state agency's interpretation of a specific provision. This really won't happen potentially with many compliance details that are provided right in the statute, right in this new affordable housing law. Also, another issue that comes to mind is what entity would one of us call or email to ask a question or ask an interpretation now of the statute. So remember, in the past, we had COA staff or the executive director was charged really by the Fair Housing Act to interpret the statute and to answer questions and provide guidelines. I think it'll be important for each of the various state agencies or this court's new program to offer and to have available that type of staffing or an availability for all of us to be able to call, email, ask questions for interpretations of this new law. Another point I'd like to make on this differentiation between having a affordable housing program detail in the statute versus having it in a state agency's regulation is this thought about in the past, we might be able to ask a COA, or in the third round that we just, we are wrapping up, we've had settlement agreements, court-approved settlement agreements that may have permitted a waiver of a provision where all parties agreed and a court approved a potential waiver of a state agency regulation. So having the details in the statute may either make it very, very difficult or just outright impossible to waive a statutory requirement. I wanted to just go back a bit to just the upcoming rule proposals and amendments. I really believe now is the time for you, for your town, your agency, your organization, to either submit informal comments or get a seat at the table at DCA or at HMFA as they tackle this very important process of looking at amendments to UHAC, to the Uniform Affordability Controls. It's important to, well, I wanted you to know that Megan York will be spending time letting you know about spending more time on the revisions to UHAC. But we, the Affordable Housing Professionals Organization, we will be getting involved in these types of rulemaking so that we can ensure that the administrative agents especially, we know over the last 10, 15 years, what are the issues that are coming up time and time again, and what needs to be worked on with the UHAC, with Uniform Housing Affordability Controls. One thing I wanted to really touch on, and it's going to be something you're going to hear from virtually every panel on this new law, and it's something that I'm going to repeat to my own municipal clients time and time again, and it has to do with, it may look like a simple point, but it has to do with when you, a municipality, submit your binding resolution, your housing element and fair share plan. There's various documents that must be submitted to the state, posted on a website, filed in some manner. And the key thing, and I'm going to say it probably 5 different times, and all of us will be saying it, is that the key thing is that whatever document, generally speaking, has to be filed within 48 hours of it being adopted. So I'm going to give you an example. We know, and Josh will let us know, that this is very important binding resolution from a municipality to start the process, that is due January 31st, 2025. So let's say your town, and many of you municipal housing liaisons, you wear multiple hats. You may be the clerk, you may be the MHL, you may be the planning board. You have so many hats on. So we want to make sure that we are all aware of this deadline provision, which is these documents must be submitted at the earlier. It's at the earlier of when an action was taken, or the deadline. So let's just say you have your only governing body meeting, let's just say, is January 15th of 2025, and you take that action. You can't just hold on to that resolution and say, oh yeah, no, we have until January 31st to submit it. No, you don't. You have 48 hours from when you have taken action. So I'm going to suggest that all of us start thinking about and telling our client, or telling our municipalities or your municipal team to be thinking about this, to be planning for it. To the point that there are times that in doing different actions of a planning board or a governing body, that there are times that you take an action and then you memorialize that action a month later with a resolution. No, you've got to be thinking ahead and plan ahead to have prepared that resolution and have that resolution adopted and memorialized if needed that same night. I'm even going to go so far as to say, have 2 or 3 people in charge of ensuring that that document, that resolution, that plan, whatever it is, have multiple backstops to get those documents, again, either filed or posted or submitted. Now is the time to start educating your team. And I do realize that, here we are in 2024 and the beginning of 2025, there's oftentimes, new people coming into office, new appointments and so forth. But hopefully no one, no town will be tripped up by that, that issue of submission at the time of adoption. I'd just like to, I've got a couple random thoughts that I wanted to, just put on the table, and all of us will be available for questions at the end of all of the presentations. So, in just preparing for this presentation, I started to think about it, again, the issue of in the past, whether, and it's been quite a while, but many of us are aware that we used to be able to call COA staff or planners. Now, granted, COA had a lot of faults, but one thing they at least tried to, be available for discussion of the statute, which is the Fair Housing Act, or their own regulations. And you could call or email, again, a staff person or their executive director and get guidance. You could go to a task force. And again, I would truly encourage that, whether it be HMFA or DCA or this new court program, that they anticipate and provide such an open access for staff to be able to answer all the variety of questions, either legal questions, planning questions, administrative agent, municipal housing liaison. There's a whole gambit of questions that will need to be answered or guidance provided. There are a number of avenues for challenges to a town's affordable housing planning efforts. As Josh noted, there are different deadlines for potential challenges. There's the typical deadlines. There's the typical avenues of challenges. You miss a deadline. The issue with missing a deadline is the new affordable housing law is that you are now almost instantaneously vulnerable to an exclusionary zoning lawsuit, a builder's remedy. It's the whole purpose of why so many towns either filed initially, back in the first and second and early part of the third round, you filed with COA to protect yourself from builder remedy lawsuits, from really having your planning efforts taken away from you, the municipality. Or more recently in the third round, as of the 2015 Supreme Court decision, it's the reason why I think Fair Share Housing Center had upwards of 360 plus or minus settlement agreements. And it's the reason why towns filed declaratory judgment actions with the court system and went through the settlement agreement process with Fair Share Housing Center. It's for that immunity, it's for that protection from a builder's remedy. So there are very specific deadlines for filing to keep that immunity, to keep that protection. I wanted to just remind and put on the table for all of you for your consideration is that another avenue of challenge that you could be up against, that your municipal, your either municipal client or your town, that you could be vulnerable to lose your immunity if you don't implement the terms of your new compliance certification. That's the new term. It had been judgment of repose most recently. Previous to that, it was substantive certification. It's now compliance certification. And there are clear avenues spelled out in the new law for challenges that you're not implementing your plan, your compliance certification. And it seems to me that there are ways spelled out more clearly of how someone could challenge that your immunity should be pulled because you are not implementing your plan. The last thing I'd like to discuss is, this is an important point, that if, again, so you heard me say that there are 360 plus or minus towns that came into the third round Supreme Court program of filing declaratory judgment or DJ actions and getting a judgment of repose, but there's about 560 plus or minus total towns. So you can hear that not every town had come into the declaratory judgment process. But if you're on the fence for the fourth round, whether you're going to come in or not, one thing I'd like to highlight is that the new law is telling us that if you don't file your plan before June 30th of next year, 2025, that you won't be able to expend affordable housing trust funds on the needed administrative functions for preparing a plan, implementing a plan, on your municipal housing liaisons, on your administrative agents. With that, I know there's so many other things to talk about, and we will be having multiple seminars, as I said, and I will again be happy to answer any questions at the end of the presentation. And I think I am transferring over to Megan.
Thank you, Mary Beth. Let me share my screen here. Okay, so I am going to talk a little bit about some administrative items that are in the law. Most of them have been touched upon already. Looks like we have a question here first to answer.
Yeah, I'll jump in to just read it. Sorry, Megan. Would it be helpful to have follow-up programming from AHPNJ on this new law? Yes, no, I don't have a preference.
And you can feel free to keep going, Megan, while the question's up. It'll be down in a moment.
All right, thank you. So as Mary Beth mentioned, we have questions and we don't have a lot of extra guidance right now other than what is already in the law. So what I tried to do is put in these slides what the law actually has in relation to administration of affordable units, and then some comments or questions on the right side of, if we could pick up the phone and ask somebody what we might start asking folks. And our hope is that over the next few months, we're going to get more guidance and also bring in more experts to kind of flesh out some of these questions. So the first thing is DCA training and certifying of administrative agents and municipal housing liaisons. The law says that DCA will promulgate a process and standards for the certification of administrative agents and MHLs, as well as standards for measuring performance and enforcing compliance by AAs and MHLs in implementing the affordable housing requirements and controls. So what this sounds like is that we're going to have a formal training and certification process put out by the state. What we think is that in order to be an administrative agent, you'll need to have this state certification. You know, from AHPNJ, we're very hopeful that we can start talking to the state about this and use the AHPNJ certification program as, you know, a substantial component of this new program for standards and certification. I know also very much hoping for clear standards for measuring performance and compliance, things like checklists and manuals of what that would entail. DCA enforcement of administrative agents. The law says that the AA will be responsible for implementing the requirements and controls. DCA may bring via summary proceedings and findings of violation of the responsibilities before a county level housing judge to docket the violation to issue corrective orders and levy fines. The MHL, DCA, and interested parties may bring a challenge before a county level housing judge to determine whether the properties are out of compliance. A finding of deliberate noncompliance may result in DCA removing the AA certification. So this, brings lots of questions about exactly what this enforcement process will look like. You know, what is deliberate noncompliance? I looked up summary proceedings because I didn't know what that was. And what Google told me is that it's a non-jury legal process that resolves disputes quickly and efficiently, such as small claims court or eviction proceedings. I think maybe it doesn't sound too easy to get a dispute clarified if there's a court proceedings, which makes me think that there needs to be some avenue for resolving disputes questions in a less formal manner. For example, an applicant disputing an income certification and things like that come up, you know, in the day-to-day life of an administrative agent in MHL. There's also some specific language for DCA enforcement of municipalities and MHLs. The MHL will be responsible for monitoring the AAs within their jurisdiction to ensure compliance with requirements. A county level housing judge may issue fines and order corrective actions for violations and may consider patterns of violations in determining whether a municipality is meeting its obligation under the compliance certification. So that goes back to what Mary Beth was saying, you know, does this mean you can lose your immunity from builder's remedy through a pattern of violations in the administrative units? What is a pattern of violation? What will the fines and corrective actions be? Some of this language about the MHL shall be responsible for monitoring the AAs within their jurisdiction. It raises questions for me about if an administrative agent is certified by the state, does that mean that the MHL has to allow them to serve as the administrative agent, or does the MHL still have some discretion on who serves as administrative agent within municipalities? Just questions we're hoping to get some guidance on. Overall, I think that this new language about standards and certification and enforcement is really positive to make sure that the whole reason why we're doing this, the creation of affordable housing units, is done properly and correctly, and the units are occupied by, you know, income eligible people through a random selection process. So ultimately, I think we are very supportive of these changes. It's just a matter of the devil's in the details and how is this going to get rolled out and what's coming next. So we're very anxious to get that information. This has already been touched upon by Josh. The new law has 40-year control periods for newly created rental units, and it keeps for sale units at 30 years. I just had a couple questions about when this 40 years goes into effect, because there's a lot of rental projects coming online and it's unclear whether they will have 30-year controls or 40-year controls. So we're hoping to get some clarity on that soon. Extension of controls. Josh also mentioned this. Just municipalities can get a credit for extending controls. The law, I won't read all this information on the slide, but it does make several reference to you need to have a total of 60 years, and you got to extend it for at least 20. And I'm wondering if you actually, if the initial controls only had 20, does that mean you need to extend that for 40 years? I think that's the case. So you get to a total of 60 years, but that's something that I think needs to be clarified. And then looking for some guidance on extension of controls for sale units. In particular, some of these units are, if they've already been affordable for 30 years, occupied by low and moderate income households, they may need some rehabilitation. So that is going to be something that may need to be addressed. And also some of these older developments do have lower HOA fees for the affordable owners. So when they're extended, it does create some issues about how to bring the HOA fees up to the same rates as the market rate of homeowners without causing a financial burden to the low and moderate income households, which is a bit of a challenge. Also, it's been mentioned previously that the law does specifically say that UHAC will be updated. I think the date is, the end of December 2024. It does mention some specific updates, and we are very hopeful that there's going to be a lot more updates than are specifically mentioned in the law. I'm a co-chair with Mark Bleckington of the AHPNJ Policy Committee. We are working on comments to provide to HMFA. We, over the past, 15 years, we've been preparing comments and haven't really had a venue to make an impact. So we're dusting off a 2018 letter right now, and hopefully getting that ready to send HMFA with some comments on recommended changes to UHAC. We are really hoping to have some other opportunities to make, as representing AHPNJ, to make some comments to UHAC. We're expecting an invitation from HMFA towards the end of May for a roundtable discussion. I don't have any other information except it sounds like it's in the works, so that's very exciting. And there's so many critical updates that need to be done to UHAC. That just goes on and on since it was adopted in 2004. So we're really hoping that there'll be a lot of things in there that will resolve questions that administrative agents and MHLs come across all the time. As I mentioned, these slides just have a lot of information about what's in the law, not a lot of answers about what it means. So some suggestions on what you can do now while we're waiting for answers is I still recommend the AHPNJ certification for MHLs and AAs to really properly administer units. Think about what changes you want to see in UHAC so you're prepared to make comments when the new rules are released. Get a good inventory of your affordable housing units with the control period, end dates and timelines, so you can think about extension of controls. Keep checking out the emails and webinars from AHPNJ with information. Mary Beth mentioned we're planning on this to be the first of several webinars. And also, we do have an AHPNJ policy committee. If you email me at megan@cgph.net, I'm happy to add you to our mailing list. We typically are not a super active committee until things come up, and then we have a flurry of activities. So we're currently meeting a couple times a month over Zoom, and we're happy to have more people joining us. I think Elaine is up next to talk about these monitoring deadlines that are coming up.
Thank you, Megan. Yes, I think I am up next, and I too will share my screen. One moment. Let's see.
So the next question that pops up before Elaine begins is, do you think the new law will help better regulate affordable housing throughout the state? Yes, no, it depends.
So while people are contemplating that, let me move ahead. As everybody probably knows, we do have some imminent deadlines. I know that we are supposed to get updates to various rules at some point, but some of these deadlines are going to hit before we have those. So what I'm going to go through is what we think is in the law right now and what kind of questions it raises in terms of the reporting that we have to do. So as everybody knows, the first deadline coming up is June 18th, and this is right from the law. The italics here are the words that are doing all the work. We're going to talk about those individually. So the first deadline is specifically to report collections and expenditures of non-residential development fees since the inception of municipal authorization to collect those fees. And the second deadline, which is in September, is the same deadline, but for residential development fees. So lots of questions about those two deadlines. Coming up in 2025, every February 15th, non-residential development fees for the previous year and residential development fees for the previous year. Get rid of that. So what does all this mean for us for this year? As others have pointed out, DCA is supposed to be setting up a website where all of this information is supposed to be uploaded and will be available. Now, I don't have any graphics in these slides, but this is where I would have put a giant pair of googly eyes, because we'll see whether this actually happens. I do see a question in the chat about how to submit various documents to DCA. We don't know yet, but this is where it's all supposed to happen. We believe that the 2024 reports, the June and September reports, should be summaries only and don't require the breakout of the most current 12 months as third round reports have done. The lawyers on the panel today may disagree with me, but that's how we're understanding the law at the moment. Yeah, they're asking for non-residential and residential fee collections to be reported separately. And I know a lot of towns have stopped tracking them that way. So we're going to have to start trying to decipher that and report them separately to the best of our ability. And this is new. Now we're apparently supposed to report expenditures separately based on residential versus non-residential. And our office is currently trying to figure out the best way to do this. And it is absolutely not even near the oven, let alone half-baked or ready for prime time. We have a lot of questions about how best to report this information. But this is what we understand the law to require. Does it have to be done on separate dates? Do we have to report one in June and one in September? Because so much of this is commingled at this point, I think what our office is going to do is report everything in June, separated to the greatest degree possible. And if we feel as though a separate report has to be submitted in September, we will likely submit the same report. And then this is a question that has come up recently. We have some towns that have passed a development fee ordinance and are trying to do the right thing by collecting fees, but for various reasons, their ordinance has never been approved by any entity. So do those fees need to be reported? We don't know the answer to that. And then the last one, this 2024 reporting, through what date should it go? And I will submit that it should go through the end of 2023. And the reason for that is my suspicion is that DCA is going to set up a website where they will post these summary reports And then in the future, we'll post the annual reports. So if the first annual report, which is due next February, is going to cover all of 2024, I don't think you want these reports due this year to cover any part of 2024, because I don't think DCA will necessarily figure it out that that would be a duplicate. So I think these reports need to be done through the end of 2023. But again, that's a question. So what does all this mean, not just for 2024, but for 2025 and beyond? Is this February 15 reporting requirement only for information from the prior calendar year? Do these residential and non-residential fee collections and expenditures still need to be reported separately? And the key for Josh, because I'm sure he still wants to receive all these reports, are the third round monitoring reports that are required by various settlement agreements still required even after submission of the June and September 2024 reports and the February 2025 reports, which are obviously before the end of the third round? So as we read the law, the answers are yes, yes, and yes. All those three things would still be true. Just before I finish, a couple of other things to know. I missed this on the first read through. New payments in lieu arrangements are not permitted. The ability for a municipality to collect payments in lieu of construction has been repealed. So we would suggest checking with your municipal attorney on the status of all existing and any proposed payments in lieu agreements that you have. A question we have: what are many municipalities that have set aside ordinances permit fractional payments in lieu? Will they still be permitted going forward? We do not know. The September 16th and the annual reporting deadlines are also for units actually constructed. And I'm glad Megan raised the question of deed restrictions and expiration dates for them, because these reports now require you to note the start and expiration dates of all deed restrictions. So whereas before we might have put only the date the deed restriction started and assumed that it is at least 30 years, now we have to add an expiration date. So what are the things we should be doing now? Obviously, we have to gather all the required trust fund information as of whatever cutoff date we determine. As I said, we would recommend December 31st, 2023. If you have CTM, that's great. In a perfect world, all these three balances should match. But in a perfect world, we all will have won the lottery and bought our Greek island. So probably we're working with imperfect information. Try to break down your development fee collections by non-residential versus residential if possible. And we have to determine how we're going to represent expenditures of these development fees. We're in the very early stages of trying to figure that out. This is a big one. Identify and resolve any non-compliance issues. If your town has spent too much on administrative expenditures based on development fees collected, need to figure out how to resolve that. You do not want to attract any undue attention to that once these reports are posted. And then put procedures in place now to start tracking all this information based on how you will need to report it. I know how we all feel about CTM, but it really can be your friend if towns will use it diligently to report collections and perhaps expenditures. It's not clear yet, but certainly on the collection side, CTM can be a huge help if we can get towns back into the habit of reporting their information on CTM. And as Megan has also suggested, get all your deed restrictions in order. Make sure you know when they were put in place and when they expire, because you will need to report that with your September unit reporting. So that's what I got. Let me stop sharing. I do see other questions in the chat that I'm sure we'll get to after Samantha speaks.
Thanks, Elaine. My name is Samantha Hennessy. I am with the Alpert Group. I am Vice President of Development here for the last 2 years. My experience with affordable housing goes back 15 years now. And I've learned from some of the best people in the business. And it's really been a pleasure to be part of the Affordable Housing Professionals of New Jersey, because the amount of folks that have been involved with this law that really has come into place over this last year, from Fair Share, the local legislation, and real boots on the ground people. Me as a developer, I then, reap sort of the benefits of all of this work that all of you have done. So thank you so much for everyone that's really invested a ton of time to really keep the affordable housing ball moving. As we sit here, and I was listening to Mary Beth talk, I pulled out the Uniform Housing Affordability Controls. And it was 2004 is the date on this. And when the settlement agreements were coming through over the last, 5-10 years, one of the biggest problems that I had as a developer was trying to work within the confines of UHAC because so much has changed. Technology has changed. The way we build has changed. We've been through a pandemic. So to really get development of affordable housing done and get it done quickly within these settlement agreements has been a bit of a challenge. And we've worked with towns, luckily, I would say especially the towns that really are promoting affordable housing, they've worked with us tremendously to make sure that we're, one, coming up with developers agreements that make sense, and throughout the compliance period, again, there hasn't been a lot of rules as to marketing and compliance of that. So for me, it's a big change that to see that UHAC is going to be amended, and I'm really excited. And I do encourage anyone, everyone, to please reach out to HMFA, DCA, and organizations like AHPNJ. To really be part of the conversation as these rules get developed, because the more input that they have, the better. And there's perspectives, from a planner, there's the perspective of an attorney, Fair Share's perspective, the developer's perspective. So to really pull all of those perspectives is really important. And I know there's been a lot of different groups that have worked together to get this law as it stands right now. And as you've heard from our last speakers, there's a lot to digest, and there's still a lot, there's a ways to go. But like Mary Beth said, AHPNJ, we will be providing seminars to you as this process goes along, and as we start to get some of these regulations in place. Two things that I really do want to mention as a developer that this law is greatly going to affect. And I'm going to be put on my sort of bad developer hat just a little bit. And we really, what I would hope to see as part of this truly is to really figure out from an enforcement standpoint what that's going to look like. That's where I'm just a little bit, hesitant on what that means in this law, because we want to make sure, especially developers like myself that do tax credit projects that receive equity from investors, and the time we have for lease up and delivery of units and making sure our marketing is done correctly. We just want to really understand what we have to do. I think that that's really important. My other concern, and I think I'll probably preaching a little bit, but it's been 30 years from a deed restriction requirement for many, many years. And, my buildings, as we develop them, typically we look at a useful life of a building is 30 years. And, when you put on these longer affordability controls, like for my company, the Alpert Group, we do own buildings that are at that 30, 40-year mark. And when you get to that point, how do you really invest money to get those units to where they need to be on a maintenance standpoint? And there's not a lot of funding out there to do that. So I get it. I'd love also, we do have in perpetuity deed restrictions that we've just closed on 2 properties. But I do just want to highlight, we really just want to keep an eye on that and make sure, again, HMFA, DCA, and the towns understand we may be coming back to them in 30 years to seek more money. One of the other points that I would like to highlight that I'm so excited from this law, so some of the bonuses that you're going to get, that towns will get, and one of them is 100% affordable housing projects. And what I've seen over the last 5 years of dealing with towns, I'm seeing this big shift to mixed income housing. And you have developers, your market rate developers that are coming in and they're required to do 15 to 20% affordable. It's hard. I'm not, it really affects that bottom line. But they're going to get it done. What I say though is 100% affordable housing projects are mixed income, right? Especially now with our requirements of having very low income units, all the way up to, if it's a tax credit project, a 60% AMI. That's a pretty good mixed income development. And I would just like to encourage towns to really look at that as a true asset. We've been very lucky to have an agency, NJHMFA, who's been putting out funding to get these 100% affordable housing projects done. Thousands of units have been developed, throughout these settlement agreements. And obviously, as this new law comes into place, we will see more. But that is one thing I definitely would like to encourage. It's hard to do other mixed income housing. We've looked at 80-20 in urban markets and suburban markets, and how the funding is right now, it's extremely hard to do. So I think if understanding, again, especially tax credit, 100% LIHTC projects have been so successful across the country. I think we just need to see more of those. I think that was really all I had time to touch on, and we wanted to take questions. So I will answer any questions that I see pop up and deliver them to the group. We have questions. I don't see questions. I don't know if I'm maybe missing it. Brian, do you see questions?
Yeah, I do. I can read them, and then if you want to field them, Samantha, they're in the open Q&A.
Okay. Would you mind?
No problem. So the first question is from an anonymous attendee. Will AHPNJ publish a model resolution? I don't even know the answer to that, but that's something that we can sort of consider and talk about at our next board meeting. But I do, think that could be useful. I'm just not able to.
Sure. Just to touch on that for 2 points, and that was actually my list of things. I think a couple years ago, Mary Beth actually and her team did an amazing job actually with trying to come up with some checklists for towns to use to create like developers agreements. And when you're going for site plan approval, that process, I think now that again, we have, this law is out, we have some more guidance. To use somebody else's phrase, dust this stuff off. I think Megan was, talking about all the UHAC comments. AHPNJ has done for years. I've seen what you guys have really put together to submit for comments. So again, to just go back to that, yes. And as we present these seminars to you, we will ask your assistance to help us try to get some of those documents together.
And I just want to add, I would hope that this, I don't know, the program, the state, HMFA, the court, someone would have documents that they are looking to see. Just like COA did during the round 3 preparation, model affordable housing ordinance, model resolution, so that hopefully we won't have to fill that gap. Would be my expectation.
The next question that I see is from Mark Healy. I am a bit confused by the first part of the formal process, i.e. municipal acceptance of the number. Questions. I believe Josh indicated that these numbers would be advisory only, but he also indicated he expected most towns to accept the numbers. And there is a very short period for towns to review and challenge them. In my opinion, that appears to make these numbers less advisory and more binding in nature. Can someone speak to that? There's follow-up questions, but I guess let's take it one.
Yeah, well, let me go one at a time. So I think the way that I read it is, and I think you're right to I think you're hitting on the right point. I think there were concerns by many involved in the process about having lived through several iterations of the failures of an administrative agency to come up with the numbers. I think there was a concern about doing that again. And so the idea here, I think, is that DCA is going to come up with advisory numbers that are not going to go through a that are not going to be themselves subject to judicial review. And that's, I think, a key thing is, so we all know, I think it's clear that at some point there needs to be a judicial review of the numbers to make sure that they check out. And so the numbers that DCA proposes are advisory. They're going to be subject to judicial review by the numbers, by what the towns ultimately come up with. I think the reason it's done that way, I think, is several-fold. One of which is, what do we, I don't expect it to happen. I don't expect it to happen at all, but let's say, in 20 years, we have a governor again who runs on a platform of opposing affordable housing and instructs DCA to just not do it. They're not going to run the numbers. And so what do you do about that? And so, and any number of different permutations for how this could come about, which is one of the things that happened, at several points under the COA process. So the numbers will be advisory. I think you're right that this is just my expectation that I think the towns probably will just utilize those numbers. Does that make them less advisory? Probably. I think towns are probably going to be in the clearest path of utilizing the DCA calculation. And so if they go to court and say, well, this is the number DCA said that it was, my guess is a judge is going to probably think that that's a reasonable thing to do, unless there's some obvious flaw with whatever the DCA has done. But I don't expect that to happen. My guess is that they're going to calculate the numbers in accordance with the statute, and hopefully it is simplified to a degree that it will, that it won't be as controversial.
And Josh, is there a way that towns can do this calculation in advance on their own? Or do they have to wait until October until this comes out?
My expectation is that if the towns wanted to, they could. I think they could probably hire that group, the eConsult group, or some group like that to do it. And I think, at this point, I mean, we already know, I mean, because of the methodology, the way that it's set up in the bill, the first two steps of the formula, we already know the statewide numbers and distilled down to the regions. And so I think mostly what needs to be done is, I think, some updated data for some of the allocation factors for the towns. And that probably answers the second question, which I'm not sure which. So the second question, where that there are draft numbers out there, I don't know what you're talking about. I'm not sure if the DCA has definitely not put out draft numbers or anything like that. So if there are other people out there that are circulating numbers, my guess is they're wrong. And I would not rely on them until we get something further from the DCA, who we have pretty good confidence are working hard on this, and
Josh, if I could follow up on just
Yep.
that point, I think it was important to hear you say that we do, on some level, know the statewide or regional numbers, and correct me if I'm wrong, but I think David Kinsey did a presentation at the Bar Association that the statewide number is approximately 85,000 for the statewide for the fourth round. But your point is it's the distilling down to the municipality level, which is really the unknown. It's not something that's going to be easy to do, because the new law is telling us that we need all sorts of data that is not, we may be able to get the data, but you have to make policy decisions on distilling that information down to the municipal level. So is that a fair statement, that statewide numbers 85,000 for the fourth round, but we don't know the
As soon as I said that the first step was known and knowable, I knew somebody was going to ask what the specific number was. That sounds in line with what I remember from David's presentation. I think it was somewhere in the mid 80s, and I think you're right. I think for the allocation factors, which are the developable land, the non-residential ratables, and then the affordability factor, I think there's going to need to be some. I think that's where the work to do is.
Yeah, I understand that. Even, and I will not say my source, but I understand that DCA is waiting on the developable land data, the Landsat data from aerial imagery. So others may know that DCA, if the DCA person was on, they may say, oh no, we just got it. So, and we're working on it.
Yeah.
It's going to be a difficult proposition, distilling the statewide number and regional numbers down to the municipal level.
And I think that's why I think that if somebody has put numbers out there, they're most obviously wrong at this point.
So, I'm gonna jump to, I guess, the last part of that question, and I'll try to go a little quicker to get through everyone's questions in the last 4 minutes, but can someone speak to the process for towns to review, challenge their number? You expect it to be analogous to the vacant land adjustment process? Yeah, we can.
Yeah, I don't know. I mean, my expectation is that once we sort of have more of this data that Mary Beth has described, that I think the way the formula is written in the bill, it should, and especially because the towns are going to be required to say how they come up with the number. So they're either going to say we did what DCA did, or they're going to say we did what DCA did, but we did this other, we deviated in this particular way. I think for a number of reasons, we're going to know where it went wrong. I think it should be relatively easy to tell where it went wrong, which is, I think, part of the design of the bill, which is why the expectation is that this is all going to be done within, challenges will be resolved in a month. Either that deviation is reasonable or it's not. It's not, we're not going to have 10 days of testimony from an expert who has some thoughts about why we should be doing a market study for, whatever, that's ultimately going to be rejected by Judge Jacobson. At this point, the formula is clear, and it should be pretty simple to really figure out where you went wrong. And I think you're going to have to tell on yourself if you are deviating. So.
Yeah, and I wanted to just chime in to say, I hope DCA is that their team, their numbers team is, trying to improve upon prior flaws, which had issues with the zip code phenomenon with in employment where jobs were actually in town A, not in town B because of zip code issues. Also a payroll. A central large hospital may have all payroll in a town, so it looks like everybody is working in that town, but they may be working from home. They may be. These are big issues that ultimately there has to be a policy determination on what path to take with some of these issues. And it would be difficult for a municipality to do it on its own, only because you have to just determine paths that are going to obviously then impact the rest of the state.
Lindsay, how do you want to handle the rest? There's many more Q&As. I don't know if we want to.
It's possible for you to either continue on if that's what you want to do, or we can also answer Q&As in a follow-up message to participants.
I think it's okay if we just take another few minutes. If does everyone here have time?
And just to let the participants know that the entire recording will be available within a week or two on the AHPNJ website. So if you need to leave now, to go to the end of the recording when it's available to look for answers to questions.
Okay, I'll keep going. And if anyone has an issue and needs to leave, just let me know.
Brian, I'll just jump in on Tom Vigna's next question.
Go ahead.
So yes, the rules definitely, the new law definitely has allows co-accrediting regulations to address surplus coming from the third round, allowing it to address the fourth round. I'll try to find it that specific, but that's a yes. That it is there.
The next question is please clarify what projects are grandfathered under old COA regulations, or what it means for projects to be grandfathered, i.e. is admin and compliance covered under old or new regs for the second and third round projects?
I'm going to just tackle that too. Others can jump in, but you almost have to go by project type. There are some changes, but as far, generally speaking, yes, compliance, COA's current regulations are in play for getting credit for first, second, third round projects, as long as they're built. If they're not built, that's a different issue.
Okay, so the next question is from Darlene Green. When would a town submit their VLA? January of 2025 or June of 2025?
I think June of 2025, because I'm thinking that January 2025 is just your acceptance of your gross general number, and then you're going to say in your plan in June of 2025 that you can't address that fourth round. Let's just say that it's a fourth round number of 500, and you do a vacant land analysis that you can do 30, and so in my mind, you'd be doing that. It's a two-step process. You'd be doing both. Acceptance of some general number. Actually, that's interesting. Whether you start to do, maybe that should be a question for your municipal attorney, whether you acknowledge up front in January 2025 whether you anticipate coming in with a vacant land analysis. That's something that this group will think a little bit more on. And okay, we'll move on.
The next question is from an anonymous attendee, specifically for Samantha. Samantha, does that mean that there will be separate buildings or specific developments with only affordable units instead of being inclusive with market rate units?
Yes, I touched on that. Yes, we we're starting to see actually a number of smaller developments, local nonprofits, doing, somewhere between your, 20 to 40 unit, all affordable, and they're able to do that through the utilization of programs like the DCA has a program, the National Trust Fund, local home funds, and things like that. And it really does start to chip away at those affordable housing numbers. And we have to, again, as a group, try to push for these smaller developments. And again, what's huge that did come out with this law, Josh touched upon the pilot, right? So if you do get trust funds from a town, being able to get a pilot, especially for these smaller projects, will be huge.
Great. So the last,
Sorry, Brian, I just want to really quick, I
Yeah,
just
sure.
want to be sure, sometimes in our, we talk about in lieu payments. I want to be sure that we're referring, because Sam, you just said payments in lieu of taxes. We are not saying that payments in lieu of taxes has been repealed. We were saying payments in lieu of the construction of affordable housing, that has been repealed. Sorry, go ahead.
Okay.
Sounds good. Thanks for clarifying. The last question is from Daniel Haubin on Mary Beth's comments that the rules for calculating municipal level numbers require some policy decisions. The rules for the available land factor calculation refers to some data sets. For example, ACS affordable housing strategy data sets that don't relate to available land. I've assumed these data sets were referenced in error. Any thoughts?
I do not at this time. I'm sorry, I don't. I'm sure there are maybe others or other folks in the participating may be able to weigh in.
Well, we could stay tuned on that one. I think that's all the questions that everyone submitted. Thank you all very much and for coming and participating. Thank you to all the panelists for helping us gain more insight on this ever-changing landscape, and hope to see you next time.
And please be aware that a survey will pop up on your screen as you exit, and we would appreciate your feedback on the webinar. Thank you so much.